Good morning. May it please the Court, my name is Don Randall. I'm here today on behalf of Citizens Bank, and with me is Carol Kam, who is also on the brief. This is a case about a loan made by an entity called GoBest, based in Hong Kong, and the loan was made to Morris Goldings, a now disbarred lawyer. The loan was evidenced by a promissory note. The promissory note was attached as an exhibit to the complaint in this matter and is at the record at A39, and it clearly shows the commercial nature of this transaction, including a very healthy 2% per month interest rate. GoBest transferred money to Goldings' account as requested by Mr. Goldings. The transfer came in by wire transfer, subject to Article 4A in the Commonwealth of Massachusetts, and there is no doubt but that this was a commercial transaction in which GoBest lent money to Goldings. Once GoBest lent the money to Goldings, it became Goldings' money.
Would you agree that if there had been client trust funds also in that account and those monies had been lost, would you agree that Citizens might be liable in negligence? Or does your argument turn on the fact that these particular monies were not client trust funds?
There are several parts of the argument, Your Honor, and that is one part of it. In fact, Rule 1.15 states that the only funds that shall be kept in an attorney trust fund or an IOLTA account are client funds. And here it is very clear that the funds that were transferred into the account were not client funds. I
understand that, but this is marked a attorney-client account. Is it your position that you simply would not have, that you had no contractual obligation to report this to the BBO because you did not understand what this account was?
That's correct, Your Honor. In fact, Rule 1.15 makes very clear that the obligation to report the existence of an account to the BBO is on the attorney. The attorney is responsible for registering that account with the BBO. And
I'm sorry, so what does that mean? So you had no reason to know that this was an attorney-client account?
No, we did not, Your Honor.
Does the under the BBO regulations or rules, a bank has to sign up, is that right?
The bank is required to sign an agreement with the BBO for if it's going to hold client accounts for lawyers.
And so I assume Citizens Bank does that for a variety of lawyers and so has an agreement with the BBO, right?
Yes, it does.
And are you saying, in answer to Justice Cordy's question, that there's no independent obligation to say anything to the BBO? It's all on the attorney?
That's correct, Your Honor. The account is supposed to be set up with the BBO by the attorney who does that. He goes to the BBO and says, I have a client funds account. It's this account at Citizens Bank, and I've directed Citizens Bank to register this with you.
Really? So the
Yes.
attorney, so then what, some message goes to you saying, hello, we have an attorney that's now registered this account at your bank and you need to report to us?
I believe that it actually goes when the attorney directs the bank to register the account with the BBO.
So Morris Goldings, the attorney is required to direct the bank to register the account with the BBO?
Yes.
Is that really how it works?
That's what Rule 1.15 says.
Where? I mean, there's 1.15E2. Is that what you're relying upon?
I would have to look at that for a minute, Your Honor.
It says each trust account title shall include the words trust account, escrow account, client funds account. And I guess this one said client account.
Right.
And then the next sentence says, lawyers maintaining trust accounts shall take all steps necessary to inform the depository institution of the purpose and identity of such accounts. Is that
Yes.
the sentence? Okay, but and you're saying that an attorney needs to do more than call it a client account?
Yes, he has to direct the bank to register the account with the BBO.
So You're saying, if I understand correctly, then the entire premise of the appeals court analysis is incorrect. Is that what you're saying? Because there was, it isn't just that this account, that Go Best's funds weren't client funds. It's that the account itself, unless Golding's registered it, there was absolutely no obligation for you to do anything with respect to this account.
That's correct, Your Honor.
As I understand, at least part of the law in Massachusetts, before a violation of a regulation can be considered as evidence of negligence, there must still be some underlying duty. And the violation of the regulation here, Rule 1.15, might be evidence of negligence if there were an independent underlying duty.
That's correct, Your Honor.
From the bank to Go Best.
That's correct, Your Honor.
Is there an underlying duty from the bank to Go Best?
No, there's none.
Does Rule 1.15 create such a duty?
No, it doesn't, because Go Best was not a client and there was no representation, as was found by Judge.
Even if it were a client, would there be an underlying duty, an independent duty from the bank to the client?
No, there would not be, because the bank is under no obligation to parties with whom it does not have a relationship. It has a relationship with Mr. Golding's. It has no relationship with people that give Mr. Golding's money.
Well, that is the general rule, but what about Eastern Bank, where the bank has sufficient notice of wrongdoing?
Well, in Eastern Bank, they found they didn't have sufficient notice of wrongdoing.
But said that if they did,
If
there
they
would
did,
be a duty.
that's correct, Your Honor, if they did. In other words, if they had sufficient notice of actual wrongdoing. And we would suggest wrongdoing with respect to the particular funds at issue, not just that somebody was up to some mischief somewhere.
Not wrongdoing in a trust account. Well, let's parse that out. Let's assume this was a registered account, because I'm a little confused about all that. But let's assume you knew it was registered with you and the BBO, and you clearly had a duty to report overdrafts.
Yes, that's correct.
And you failed repeatedly to report them.
Yes.
Thus indicating that there was some misconduct in the account, because those are not permissible in client trust accounts.
That's correct.
Then wouldn't you be on sufficient notice of wrongdoing to have some duty to inquire further?
No, that's not what the case law would suggest. If you look at the cases relied upon by the appeals court in its decision, in particular the Lerner decision and the Amoroso decision, there were significant overdrafts in the admittedly or allegedly attorney-client funds account, and the banks also had specific knowledge of the wrongdoing.
One of the banks didn't.
They both.
The third bank. There are three banks in the Lerner case, aren't there?
There are three banks in the Lerner case, and one bank did not participate. One bank closed. David Schick was the bad lawyer in that case.
Right.
One bank closed him out pretty quickly when they figured out what he was up to. But the primary actor in there was Fleet Bank.
Right.
And the allegations in that complaint were that Fleet Bank was complicit in the fraud.
Oh, absolutely. Fleet Bank, at least the allegations, are really quite
Yes.
damning and far
Yes.
beyond this. There's no question about that. But what about the third bank?
Amoroso?
The third bank in Lerner. Was it Home Savings?
That's the Amoroso against Home Savings case. That's a separate case. There was Sterling, Republic, and Fleet were the banks in the Lerner case. And
It was Sterling.
in one of the banks, I believe, shut down Lerner very quickly, and so that was not at issue. The court was very clear to state that clients of Schick whose funds were not deposited in a particular bank, those banks were not liable to other clients of Schick's. They couldn't be liable because of a bank's knowledge of sort of a general fraud going on. So,
What consequence, if any, does the bankruptcy court decision that Go Best was not a client of Golding have on whether this was a trust account?
it has it relates more specifically to the funds at issue, Your Honor. In other words, Massachusetts Rule 1.15 states that the account shall only contain funds in connection with a representation. And here it's very clear that the relationship between Goldings and GoBest was that of debtor and creditor. He borrowed money from them. There was no fiduciary relationship, and there was no representation of GoBest as a lawyer. And Judge Hillman was very specific in his findings in that decision.
Is it your view that there's any collateral estoppel effect here with regard to that finding or not?
Absolutely. There was an evidentiary hearing. The evidence was, there was testimony taken. Judge Hillman reviewed the documents, and I believe that this court would be bound by those findings, that there was no relationship. And in fact, independently, I think this court can conclude there was no such relationship because Goldings borrowed money from GoBest. That's it. And the money came in by wire transfer, and Goldings agreed to pay back GoBest. And the other thing is that once the money comes in to Goldings, it's not GoBest money anymore. They make a great deal.
Well, let me ask you a question then with regard to this. Let's assume the person gives notice, an attorney gives notice of a client account, tells the bank this is a client. I'm acting as his attorney, but in fact is using that client account for matters that are wholly unrelated to any attorney-client relationship. It's an investment relationship.
Yes.
The bank had knowledge that it was a trust account, but it wasn't. Would the bank be responsible for wrongdoing if it turned out not to be an account, even though the bank understood it to be?
It depends on the particular circumstances and the bank's knowledge of what the attorney was doing. If the bank, for example, in your question, knew that Morris Goldings was providing investment advice to people, and was taking money and investing their money, and they sat down and looked at the account and said, this doesn't look like the activity in a normal attorney-client funds account. What are you doing? And he said, well, they're sort of my clients, but I'm making investments for them, and I'm doing this, and the bank is on notice of what he is doing, then I think the bank would have some issue about, or there would be an issue with respect to its knowledge about what it was doing. In this case, that's not the situation. Here, it wasn't registered, and the bank had and because of the nature of contemporary banking processes and procedures, the money that came in appeared in that account just by the systems. There's no human eye that looked and said, oh, Morris has gotten $5 million from somebody in Hong Kong. The money just appears in the account, and under Article 4A, it has to be credited to that account more or less immediately. And once it's credited to the account, an authorized signer, in this case, Morris Goldings, is able to take the money out and do it. And there's no obligation on the bank to look and see what he's doing there. And even the Lerner case goes so far as to say that a bank has no obligation to its depositors' creditors to make sure that its depositor behaves in a certain way so as to be able to satisfy the debt to the depositor's creditor.
Mr. Randall, I have a concern about a background issue that I don't see in the briefs, and it may not even be an issue, but I don't have doubt that that we, as the regulators of the legal profession in Massachusetts, can require lawyers to set up trust accounts and obtain agreements for specific kinds of accounts with banks. But is the banking industry itself so heavily regulated that we do not have the authority to impose a trust on banks, totally independent of our ability to regulate the profession?
I don't believe that as regulators of the legal profession, you have the right to require the bank to behave in a certain way.
Well, we can make sure that a lawyer doesn't deposit
That's
money
correct.
into a bank unless the bank agrees to that
yes,
kind of an
absolutely, you have the right to do that.
But is the bank, and does it depend on if it's a state bank, a federal savings and loan association? Are these different types of banks so heavily regulated that we have no authority to impose a trust on the bank?
You have no authority to require, for example, you don't have authority to require every bank in the Commonwealth to offer attorney-client account subject to your regulation.
But we do say, if you agree, you must be subject to our regulation.
Absolutely, you
and-
absolutely have that authority, and that's true in, as I understand it, all 50 states. So that's the.
And that was the rule in New York when Lerner was decided.
The rule in Lerner was slightly different because in Lerner, and we point this out in the brief, the New York equivalent of Rule 1.15 is not strictly limited to funds in connection with a representation. It's any funds incident to the relationship between the client and the attorney.
I'm sorry to keep you, but I want to go back to where we began, and that is the premise here. This account, you say, Mr. Goldings didn't register this account with the BBO, if that's a requirement, and he didn't inform the bank that it was a client account?
That's correct.
Where in the record is this set out?
But it was called a client account.
That's a name. It's in the record in that somewhere in our brief we say it was simply a demand deposit account that he established at Citizens Bank and did not tell Citizens Bank that it was a client funds account.
With respect to all of the other lawyers, and I know you have lots of lawyer accounts in your bank, what is different about this account?
What's different? This account is different from the other lawyer accounts in that the other lawyer accounts are set up on the system so that if there is an overdraft, the system generates an overdraft notice that goes both to the lawyer and to the BBO.
And why wasn't this account set up on the system? I guess that's what I'm getting.
It was not, when Mr. Golding set up the account, he did not tell the bank, this is going to be an account that must be registered with the BBO.
And that's the basis on which you determine whether an account goes into the system or not, and therefore is
Yes, and
in
that's
accord with this agreement you have with the BBO.
Yes, and that's consistent with Rule 1.15 in that it places the burden onto the lawyer to do that.
So is there anything in the record, I know this is not a full record, but is it,
There are indicia on the account statements of Mr. Golding's account that were attached as an exhibit to the affidavit submitted by GoBest counsel, showing that the account statement was mailed to his home address, interest was credited to the account rather than in the situation of an IOLTA account where the interest is credited to the BBO, or in the situation of where an attorney is holding funds as an escrow agent, the interest is credited to one or the other of the parties that have an interest in those funds.
so you're saying this is not a contested issue of material fact? I mean, this was essentially a summary judgment, motion to dismiss,
Yes.
summary judgment ruling.
No, I think what the GoBest contends is that because of the name, it was a client account, and therefore all of these protections should ensue. In this particular instance, that's an unreasonable contention because they made a commercial loan to Mr. Golding's. They knew that they weren't client funds. They became Mr. Golding's funds once they went into the account, and Mr. Golding's could then do with the funds as he saw fit. So,
Thank you.
thank you.
May it please the Court. Eric Langland for GoBest Assets Limited. I'd like to clear up one point. There is no evidence in the record at all that Goldings told the bank that this was not going to be a client trust account.
Well, it sounds from Mr. Randall as though it's not, did he tell him that it wasn't? it's that he's required to tell them that it would be.
There is no evidence at all that he told them anything. The rule...
If he says nothing, that means not. I mean, that's what I take nothing to mean.
I don't believe it can be that simple, Your Honor, because we know it's Morris M. Goldings, the named partner from Mahoney, Hawks, and Goldings, and they have an IALTA account for Mahoney, Hawks, and Goldings. And the same Citizens has the same has an account for them. They know he's a lawyer. They know that's his business, and they name it Morris M. Goldings client account.
How do you interpret the rule, Rule 1.15? Does that require the attorney to register the account?
The attorney is required to tell the bank that that is a client account or that it is a trust account, but the bank has an independent duty simply because the bank has said, we're going to accept IALTA accounts, we're going to accept trust accounts, and therefore we are going to abide by the SJC's requirement that we report the overdrafts to the bar.
Well, does the record tell us whether Goldings had another IALTA account?
That Mahoney, Hawks, and Goldings did.
Mahoney, Hawks, and Goldings sure did, had it at Citizens Bank, yes.
So does it follow that every other account that Goldings had would have been an IALTA account?
It doesn't necessarily follow that, but what we have is a bank that's an account that's named Morris M. Goldings client account, and what we know that occurs with that account is he pays legal bills from Mahoney, Hawks, and Goldings from that account. He's taking retainer money into that account and paying bills for legal services to Mahoney, Hawks, and Goldings.
But why should you benefit from all of this when you are not a client? These are not funds entrusted to an attorney in connection with representation. Why should you benefit from whatever bank obligations the bank has with respect to client funds?
I disagree with that characterization entirely because the funds, first of all, were client funds. The rule is broad because it says it's funds of clients and third parties in connection with representation. The rule is written very broadly.
But representation means legal representation.
No, it does not mean legal representation. It says, it enumerates several instances. The rule says several instances where it could be other things, as a fiduciary, as an executor, as an agent, and it says, or otherwise. Presumably, this court could have written that rule and just said, in connection with a legal representation. Or it could have just said, only for legal clients. But it didn't. It made it very broad, and the reason is because attorneys sometimes come into funds that they are supposed to safeguard. That protects the public and it protects our profession because it means that a dishonored check will be reported to the bar. Those dishonored checks are the teeth for the rule.
Well, let me ask you this. Did you retain Mr. Goldings as your legal counsel? Or in connection with legal advice?
The bankruptcy court found that there was no legal representation. But what was done in this case was GoBest's funds were provided to Goldings for the purpose of investment. He was a fiduciary as an investment advisor or as an agent, or because he was given funds for a specific purpose. He was supposed to carry out a specific purpose. But again, we're looking at very narrowly at this one particular transaction. What the rule requires, what a trust account is any account that has trust funds. This account was established long before GoBest money ever went in there, and it was established. It contained client funds, and because it contained client funds, it was subject to Rule 1.15. The bank disregarded.
Regardless of whether the attorney took what the required steps under the rule.
Yes, and it doesn't matter whether GoBest's funds were in the nature of a legal representation or otherwise.
So the bank has a duty when there is an attorney setting up an account and a duty to determine whether this is a trust account or just an operating account or some other investment account?
Yes.
The bank has a duty to determine that.
Yes, at the appeals court, Justice Rubin asked, well, can I establish a account called the Peter J. Rubin Trustee of the Don Randall Trust account? And of course you can't do that. I can't make the, just open an account and call it the Bill Gates Fund account. There has to be some, so you can't open a Morris M. Golding's account, client account, and expect that, it's just a regular account. That's an account used for an attorney who they know is an attorney.
Well, if the
doing
attorney had
business.
commingled, let's say his kids, several $1,000s of his own kids' money, his children's money, put it into the client trust account, commingling assets, would that money be protected?
If the obligation would still be if there were an overdraft,
But
the bank.
could his children bring a claim against the bank because the trust was violated? There was a failure to report to the Board of Bar Overseers?
If it were chronic and severe overdrafts, yes, they could. And the reason is,
The money's illegally in the account.
well, again, the point is, the definition of a trust account is anything that contains trust funds. And when we have,
You're not saying these are trust funds, are you?
yes, we're saying that the monies that went into this account
No, I
long
mean
before.
Go Best's money. You say that's trust money that
Yes.
he's holding in trust?
Yes, Your Honor.
What if he had put what if he had put that money into his office his office management account?
I don't know that we would have a claim. And we would.
Because there was no trust relationship between him and Go Best.
What makes this a account with different duties is it was a trust account. It held clients' funds. That's what the requirement of the rule says. Once it holds client funds, the bank has certain obligations.
But I thought, I'm just focusing on the nature of these funds. Forget, if the same funds were put into the operating account of Mahoney, of Goldings, you wouldn't have a claim. Is that what you're saying?
Yes, we would not have a claim.
Same relationship between Goldings and Go Best.
That's right.
But
we would say.
when those same funds, same relationships are put into the client account, they become trust funds just because that's the account they're in?
The account does not become a non-trust account simply because the attorney puts something else.
I'm just talking about the nature of the funds.
Yes, the nature of Go Best's funds was he was a fiduciary. He was given those funds as an investment advisor or as an agent, and therefore he
But
had
you
to
just
put
told
them.
me that if you put them in the operating account, they wouldn't be considered trust funds. Just confused.
I'm sorry. Maybe I didn't give you a proper answer. They would still be they would still be trust funds. They would be funds that he would have to safeguard.
Okay. All right.
But if he did put them in the other account, he would violate his obligation to he would have put them in the improper account. But the point I was trying to make is it's this account, an account with trust that contains trust funds or client funds where the obligation is to report.
It doesn't matter what really. Once they're in that account, it doesn't matter what their origin was. That's your view. It's not Judge Barry's view, but that's the majority view in the appeals court. Once they're in that account, whatever the relationship is between Goldings and Go Best doesn't matter because now they're held in there and the bank has, because of the nature of the account, the bank has an independent duty.
Yes, Your Honor, and that is the nature of the account here is there is no evidence other than to suggest that client funds were kept in this account.
But wasn't the duty to protect clients? The whole purpose of Rule 1.15 is to protect clients, legal clients,
But it's
people
broader
with
than
whom
that.
the lawyer has an attorney-client relationship. That didn't exist here.
It's broader than that, Your Honor. There's no reason to limit it simply to legal clients because attorneys come into funds.
But it's in the course of their representation. They may be holding escrow funds.
They may be an agent or an investment advisor, as Goldings was in this case.
But not as a lawyer. It didn't come into his possession by virtue of his position or his status as a lawyer.
I would disagree with that. I believe that that is entirely the reason. It was him, through his practice, having a client that knew about the Starwood transaction. That was the entirety of the reason why they invested the money. And the reason he was able to do this was because of his status as what was considered to be a respected lawyer.
By taking possession of that money, did Goldings have an obligation as a lawyer to put the money into his client account?
He had the obligation to put it in a proper client account that was going to.
So you're saying that he did have an attorney-client relationship with Go Best?
No, Your Honor. I am still saying that he had a fiduciary relationship.
If I could turn you to the issue of causation. The bank here, I gather what you're saying the bank should have done, and all the bank should have done, is to, upon learning of substantial deficiencies, made sure that the BBO was aware of those notices.
Yes, Your Honor.
And that's all that they should have done.
They could have satisfied their duty in two ways. One, they could have notified the BBO. Simply, there are dishonored checks here, in which case the BBO would investigate and the presumptive sanction would have been disbarment. That would have been 6 months before GoBest sent its money. The second thing is that where they could have they could have simply investigated or inquired as to what was going on with the scant wire there. These bounce checks.
Okay, but you're saying that if they had given that notice, that would have sufficed?
Yes. If you look at any of the documents contained in the record, this account is horrible. It's got cash going in. It's got ATM withdrawals. It's got bounce checks galore. This account is an abomination.
So how are you going to, so let me imagine they had done that, and imagine the BBO failed to act or acted slowly. Can you bring an action against the BBO for negligence because the BBO had this information and failed to take action against him, and therefore your client suffered?
I don't believe we could, and we wouldn't be extending it that far.
Okay, so I guess, but why? I mean, how are you going to prove causation here? It would go to the BBO. How are we to know that the BBO would have acted promptly enough to have protected your client? How are you going to prove that?
Because we appoint the BBO. No, I'm kidding.
I can't say how quickly they would have responded, but certainly there would have been a notice to the BBO that there were dishonored checks. Goldings would have also gotten notice of that, and we don't know how quickly they would have responded. But presumptively, the sanction is disbarment. And had they looked at any of these, and these were severe overdrafts in instances of $760,000, presumably the bar would have recognized that the trust funds are really at risk here and acted promptly. We also have a cause of action for aiding and abetting, and aiding and abetting in this instance is a knowledge and substantial assistance of an underlying wrong. In the situation that we have here, what we find is not only does the bank know that there are substantial and severe overdrafts in this account and it allows it to continue to operate, but it also knows that Goldings at one point came into Citizens Bank and with the help of Calvin Wong, a Citizens Bank employee, moved $200,000 from an IALTA account, the MHG IALTA account, and put it into the Morrison Goldings client account. So,
okay, and you quote something as saying he knew he shouldn't have done that to Miss Frankie, I guess he said that.
That's correct.
But that had nothing to do with GoBest, correct?
Those funds did not have to do with GoBest. That's correct. In an aiding and abetting claim, you don't have to prove, that the funds involved.
That the wrongdoing related to the actual you don't need,
No, you don't have to prove that it
just the
related
using,
to
the misuse of the accounts, aiding and abetting the misuse of the account,
knowledge.
generally.
Yes, knowledge and substantial assistance, but you don't have to show that the bank knew that it was particularly go-best funds that were being taken.
How
You
long
didn't have
ago,
to do that.
how long before, or what's the temporal relationship between that transfer of the IOLTA $200,000 and Go Best deposit?
It's about 6 months. It's,
The transfer was 6 months before, is that, or
yes,
after?
yes, that's correct. That's correct. And the Kahali case indicates that Merrill Lynch didn't know of the wrongdoing, or wasn't required to know about the individual plaintiffs' funds. So we're not required to prove that they knew about Go Best funds specifically.
Well, counsel, we'll have to leave it there. Thank you very much.
Thank you, Your Honor.